Okay, I think we'll make a start. สวัสดีครับแล้วยินดีต้อนรับทุกท่านมาร่วมเรียนด้วยกัน
Right. Hi, good afternoon and welcome. My name is Nawin. I am a lawyer who works with the Remedy Project in Hong Kong. Before we start the program today, is that we have interpreters online. So if you want to listen, you can choose English or Thai. Just click on interpretation and which is the globe. So now I'm going to be speaking English. Thank you.
Hello and welcome everyone to this training session looking at international legal frameworks on human trafficking law as well as principles of human trafficking practice. Before we start, just a little bit of housekeeping. If everyone could please make sure to keep your microphones on mute if you're not speaking. And as well, if anyone needs interpretation, there is an interpretation button at the bottom of the screen. Please just select the language, English or Thai, whichever you prefer. And if you have any questions or if you have any difficulties, just write your questions in the chat box or put your hand up and we will help you. As well, we also have a
ใน
pre-training.
ขณะเดียวกันนี้เราก็จะมีเซอร์เวย์ที่เป็นเรียกว่า pre-training นะคะเป็นเซอร์เวย์สั้นๆเนี่ยนะคะ
to fill that in if you have some time. And just lastly for everyone
แล้วก็ท้ายสุดนี้เดี๋ยวผมจะเปิดแชร์สกรีนให้เป็นภาษาไทยนะคะดังนั้นสำหรับคนที่ต้องการสไลด์ที่เป็นภาษาอังกฤษเดี๋ยวจะโหลดไว้ในแชทบ็อกซ์นะครับขอความกรุณาคลิกไปดูฟังได้นะครับหรือไปดูได้เอาละครับเมื่อเรียบร้อยแล้วก็ขออนุญาตส่งให้คุณซาร่า
to say a few introductory words. Please go ahead, Sarah.
Thank you, Nawin. Thank you and good afternoon, everyone. So this is Sarah from Windrock International. Windrock is implementing in the region the USAID Asia City project. USAID Asia City project is a 7-year program funded by USAID that focuses on transnational and regional challenges to combat human trafficking.
ต่างๆด้านการค้ามนุษย์ในภูมิภาคเอเชียค่ะทีนี้ในการทำงานส่วนนี้เนี่ยเราต้องการที่จะเสริมสร้างความแข็งแกร่งนะคะในเอเชียโดยที่เราจะพัฒนาโมดูลการฝึกอบรม3ชุดด้วยกันนะคะเพื่อที่จะให้อบรมประเทศไทยคนในประเทศไทยแล้วก็บังกลาเทศเราทำงานร่วมกันในกัมพูชาด้วยค่ะเพื่อที่จะสนับสนุนการ
an online meeting and hopefully we will have soon also in-person meeting. So today we are here to launch the 3 modules for Thailand. We will launch 1 module for each week, starting module 1 this week. All training materials, including videos, are now available on Thailand CITIP, USA Thailand CITIP Resource Toolkit website. You can see the link in the chat. I just want to thank, first of all of you for joining this meeting and to thank the USAID Thailand City project to help us developing the manuals and organizing this meeting, IGM Thailand and all the organizations that help us to finalize this training material and also to organize this series of events. So that's all from my side. Thanks a lot for joining. I really wish you a productive meeting. And I'm going now to hand over to Archana, the CEO and founder of the Remedy Project. Thank you, and to you, Archana.
Thank you, Sarah, and a very warm welcome to everybody to this session. My name is Archana Kotecha. I'm the founder and CEO of the Remedy Project, and we've had the pleasure of working with Windrock and being supported by USAID in producing these 3 modules. Again, thank you to everyone who contributed to this. Now, just to give you a quick roundup, we will be taking you through 3 modules over a period of 3 weeks. The first module really sets the scene around international standards. A question we get asked very frequently is, why do you need to know about international standards when the local laws are what is relevant? Because that is what we deal with on a day-to-day basis in our work. Now, the local laws have evolved from somewhere. They've evolved and find their origins in international standards. For that reason, in order to best apply local law, it is really important to understand the context from which it has come. And the international standards often reflect the gold standard in terms of what is the most desirable, but it's often not the most suitable at a local level, which is why local level implementation is necessary. However, it doesn't take away from the fact that there is a wealth of knowledge and understanding which is encapsulated in these international standards. This is why Module 1 is really important. The most important aspect of Module 1 is really distinguishing the different elements of crimes of exploitation.
องค์ประกอบต่างๆนะคะของการแสวงประโยชน์นะคะของอาชญากรซึ่งเวลาคุณดูในเรื่องของการนำอาชญากรต่างๆนี้แล้วคุณจะเห็นได้เลยว่าแต่ละบ้านก็จะมีการสร้างรั้วกันของกันและกันแล้วก็ต้องพยายามเข้าใจว่าอะไรคือการป้องกันในแต่ละส่วนนี้นะคะมันอาจจะหมายถึงหลายอย่างนะคะมันอาจจะมีบางประเด็นที่ไม่เหมือนกันในแต่ละประเทศเพราะฉะนั้นมันจะต้องเข้าใจวิธีการที่เราจะปกป้องคนเหล่านี้นะคะโดยเฉพาะยิ่งในโลกที่มีการแสวงประโยชน์กันมาก Module 2 นะคะเป็นเรื่องเกี่ยวกับกรอบและก็งานนะคะอันนี้คือสิ่งที่เราพบกันอยู่ในว่ามีอะไรบ้างอยู่ในแนวทางปกตินะคะที่ในประเทศแล้วก็เวลาการดูแลผู้ที่ตกเป็นผู้เสียหายนี่คืออะไรนะคะทำอย่างไรทีนี้เราก็เป็นเรื่องเอาแนวคิดของชุดแบบเรียนที่1เนี่ยแหละเข้ามาประกอบในโมดูล 2 โมดูล 3 แล้วก็มีเรื่องของการทำงานข้ามชายแดนนะคะแล้วก็ในหลายกรณีเลยเวลามีการแสวงประโยชน์ทางเพศมีการกระทำอาชญากรรมก็จะมีมิตินะคะที่ว่ามีทั้งผู้เสียหายแล้วก็ผู้กระทำความผิดเนี่ยย้ายไปจำที่ต่างๆนะคะบางครั้งก็จะมีการประกอบอาชญากรรมนอกประเทศหรือในประเทศดังนั้น
When you're working on these cases, how do I work these different angles? How can I think about, building a case or building an investigation using different elements that bring together and that really demonstrate how this crime has happened and how it has affected people. The business and human rights space is becoming very, very busy and active, with many of you having heard about the European mandatory law on due diligence, many modern slavery regimes, etc., which present new opportunities for accountability.
ความยั่งยืนดังนั้นก็เป็นโอกาสมากเลยอันนี้มันถึงเป็นเรื่องสำคัญมากเลยที่คุณจะต้องเข้าใจนะครับว่าถ้าสมมุติว่ามันมีกรณีที่มันมี supply chain แล้วก็ห่วงโซ่อุปทานคุณจะใช้อะไรล่ะที่อยู่ในพื้นที่เนี่ยเพื่อที่จะสร้างเป็นเหมือนคดีที่มีเคสที่เหมาะสมแล้วก็คุณสามารถที่แล้วก็นำไปapply กับที่อยู่นอกประเทศนะคะในโมดูล 3 เนี่ยต้องดูเรื่องความเชื่อมโยงต่างๆเพื่อที่คุณจะสามารถจะเมื่อคุณเก็บหลักฐานมาแล้วคุณจะสามารถที่จะประกอบเป็นองค์คดีแล้วก็ develop ตัวเคสของคุณขึ้นมาได้ดังนั้นสิ่งที่เราอยากจะทำมากๆในเรื่องนี้นะคะก็คือว่าความเข้าใจนะคะของนิเวศวิทยาของการแสวงประโยชน์อย่างที่2นะคะตัวนิเวศที่มันองค์ประกอบเนี่ยมีอะไรบ้างเป็นอะไรสำหรับคุณแล้วหน้าตาอย่างไรที่บ้านของคุณนะคะอย่างที่3ก็คือเพื่อจะสร้างความเข้าใจนะคะว่าวิธีการทำยังไงที่จะให้พ้นประเทศไทยไปฉันนั่งอยู่ตรงนี้ที่ในประเทศไทยแล้วถ้าจะออกไปเนี่ยจะทำยังไงนอกประเทศดังนั้นก็ขออนุญาตให้คุณ enjoy โมดูลต่างๆเหล่านี้ก็หวังว่าคุณจะมาคุยกับเรานะคะขอติดต่อเราได้เลยถ้าคุณต้องการอะไรแล้วอยากมีประเด็นอะไรที่คุณอยากจะให้เราพูดถึงนะคะขอบคุณมากขอเรียนเชิญคุณนาวินค่ะรับต่อ
Great. Thanks very much, Archana. With all that in mind, I will now share my slides, and hopefully you can all see these. If you can't see the slides, just send a message in the chat. And also, for those of you who need the English versions of the slides, you can find a link to the English slides in the chat box. And if you need us to send them to you again, just send a message in the chat box and we will send you the English language versions of the slides. So I want to begin then by just giving a brief overview of what we're going to cover in today's session of about 2 hours. We're going to be focusing on two things in today's session, two topics, I should say. The first topic we're going to look at is focused on the international legal framework around human trafficking. So these are looking at the international standards and human rights instruments that relate to human trafficking. And the second topic we are going to look at is some general principles which come from those international standards, such as, for example, do no harm and the rights-based and victim-centric approach. And in the middle of those two topics, we'll be doing a short group exercise. And I'm hoping to be able to wrap up this training by 5 o'clock Thailand time so that you can all get home at a decent time. So I hope that we can move through these topics at a decent pace. But as always, if you have any questions, comments, send them through to the chat, and I will try to. Oh, I'm sorry. I think I'm speaking a bit too softly. I will try to do my best to answer your questions as best I can throughout. So with that in mind, let's move on to the first topic I want to cover today, which is looking at the international legal framework relating to human trafficking. So before we get into the international legal framework, I want to start by just providing an overview of what we like to call the spectrum of exploitation. And what we really mean by this is when we talk about things like human trafficking, forced labor, migrant smuggling, we're really not thinking about these things as individual things that exist on their own. Rather, the way to think about them is to perceive all of these different forms of exploitation as existing on a spectrum or a continuum of exploitation, because there are overlaps between all of these different types of exploitation. So it's often not the case that we can neatly put one situation into a box that says, okay, this is trafficking, this is forced labor. It's often more a question of degree. And so we have to imagine that all of these different types of exploitation exist together as part of a broader ecosystem of exploitation. And some of you may have heard the term modern slavery before. And really, modern slavery is one way of describing this spectrum of different forms of exploitation. And it's important to be able to understand and differentiate where different situations fit along this spectrum of exploitation, because different types of exploitation require different types of intervention and different kinds of responses. So we wouldn't treat someone who is subject to some low-level, simple labor law violations in the same way as we would treat someone who is a victim of human trafficking. So that's why it's important to be able to situate situations along this spectrum. And that's what we'll try and do as we go through the different legal definitions in this first topic. So looking first at the green end of the spectrum, here we have sort of the ideal situation where people are in fair and decent situations of work, where they're treated in line with international standards. As we move further along, we might start to see situations where people have difficult work situations. They may have to work long hours. Their pay may not be very high. but it's still not illegal. There's nothing illegal happening here. It's in line with the law. And as we move further along, what we start to see is situations of violations of the law. So maybe someone is not paid their salary, or the minimum wage is
ไม่ได้รับรับเงิน
and in those situations, we start to see some violations of the law. But there isn't perhaps a more serious side to it. So as we move further along, we start to get into the realm of things like forced labor and human trafficking. And here we start to see not just labor law violations, but situations of deception, coercion, exploitation, unfairness coming up in the victim's situation. And that's when we start to move away from just this is a violation of labor law into, okay, this could be a situation of human trafficking or forced labor. And then at the very far end of the spectrum, we have what many would regard as the ultimate form of exploitation, which is slavery, which is where a human being is treated like another person's property. And each type of exploitation along this spectrum needs different types of responses. So if we're dealing with a situation of poor working conditions, or maybe some low-level or sporadic labor law violations, then maybe we can resolve these through informal situations, like maybe some negotiation or some mediation, or maybe a company has a complaints mechanism or a grievance system. But as we get into the yellow part of the spectrum and we start to see legal violations, then we need to change the way that we respond. And maybe now we need to think about legal responses like the labor tribunal, the fines, or civil claims, or complaints to regulators, like complaints to the Department of Labor. And then once we move into the red side of the spectrum, that's when we really need to look at law enforcement responses, right? We need to involve the police and law enforcement agencies because we're dealing with serious crimes. And so that's why it's important for us to be able to understand the different definitions of these different concepts, how they overlap, and how we can try and distinguish between them, because this will inform the way that we respond to situations and the way in which we interact with victims. And so I want you to keep this in mind as we go through this training, because we're going to keep coming back to this as one of the key concepts that underpins what we're going to be talking about today. So with that in mind, I'm going to move on now to look at the key terms, concepts, and definitions relating to human trafficking under international law. As Archana mentioned before, in next week's session, we're going to look at these same topics, but under Thai law. So as a starting point, we're going to focus first on the international definitions, so we can understand where the Thai law comes from and how Thai law relates to these international standards. So the foundational instrument in the space of human trafficking is an international treaty which is known as the Palermo Protocol. The Polymer Protocol forms part of the UN Convention Against Transnational Organized Crime, which was entered into force in 2000, and to which Thailand is a party. The Palermo Protocol has been signed by over 192 countries, and so it really is the basis of most countries' laws on human trafficking. The Palermo Protocol does a few things that it's important to know. First and foremost, the Palermo Protocol defines the crime of human trafficking under international law. It also requires signatories to criminalize human trafficking under their domestic law. It provides for basic rights of trafficked persons, which we'll cover a bit later. it also provides a framework for international cooperation in terms of information sharing, law enforcement cooperation, and repatriation of trafficked persons. So the Palermo Protocol does a lot more than just define human trafficking. It actually provides for some basic rights and also some international cooperation around human trafficking, which we'll come back to in the later modules of this training program. So how does the Palermo Protocol define human trafficking? Well, as some of you may know, the Palermo Protocol uses a three-part structure to define human trafficking. And the definition consists of three parts. The first is the act, the second is the means, and the third is the purpose. And together, these three parts make up the definition of human trafficking under the Palermo Protocol. So the act can be considered what is done by the perpetrator. So thinking about what was physically done by the person involved. And the Palermo Protocol lists 5 acts here: recruitment, transportation, transfer, harboring, or receipt of persons. And each of these things on their own is obviously not criminal. It's not a crime to transport people. It's not a crime to recruit people. It's not a crime to receive people. So what makes these acts criminal is when these acts are done together with the other two parts of the definition, the means and the purpose. Now, most of these acts are fairly self-explanatory. The one that some people have issues with is the harboring, the concept of harboring. And harboring really refers to the keeping, the housing, the providing of accommodation for a person. So, for example, and it doesn't mean confinement. So harboring is not the same as confining someone. So you could harbor someone by locking them up in your house, but equally, let's say an employer hires some migrant workers and the employer keeps the migrant workers in accommodation on the factory, so provides the workers with a place to live in their factory. That could be considered harboring. Or let's say I hire a domestic worker to live in my house. Then me providing a place to live for my domestic worker, that can also be considered harboring. So harboring doesn't necessarily mean keeping someone in captivity. It just means providing a place for someone to stay or to accommodate someone in the most simple terms. So the second part of the definition of trafficking is the means. And the means can be considered how the act is performed. So the way in which the act is carried out. And again, there are 6 means which are specified in the Palermo Protocol. And they cover a whole range of different things. But the common element of all of these things is that they take away the victim's ability to consent. So they take away the free will of the victim. So, for example, we have the threat or use of force, so physical force or threats. We have coercion. And coercion can be considered any form of physical, psychological pressure on a person. So coercion doesn't have to be physical. For example, one very common method of coercion is what we call debt bondage. So you can use someone's debt that they owe as a way of trapping someone and taking away their free will, because someone who is in a situation where they may be working for an employer and are under difficult working conditions may feel like they can't leave because they owe so much money either to the employer or to a recruitment agent or someone else that they can't freely leave the work because they owe so much money that if they stop working, they won't be able to repay. So that can be a form of coercion, where that debt is used as a way to pressure someone into not leaving a situation where they're being exploited. Other forms of coercion could, for example, include where an employer gets someone addicted to drugs as a way of maintaining control over them. And we sometimes see this in the context of sex workers. Other forms of coercion could include, for example, let's say an employer of a migrant worker takes away the worker's passport. So the worker no longer has their passport, so they can't leave their employment. That's a form of coercion. Or let's say an employer hires a migrant worker from Cambodia or Myanmar, and they don't have a visa, so they come to Thailand illegally. And the employer says to the worker, well, if you leave, if you try and run away, I will call the police and you will be arrested and sent to prison for being an illegal worker. That is a form of coercion. So really broad concept that encapsulates any kind of pressure that's to the point where the person no longer can really exercise their free will. Some other means, which are a bit more self-explanatory: abduction, fraud, deception. So here, someone could be kept in a situation of exploitation because they have been tricked, they have been deceived. So, for example, someone says to a worker, you know, if you leave, I will harm your family. Now, that could be a form of threat or intimidation, but it also could be a form of deception because they could be lying. They have no ability to harm your family or no intention of harming your family. So they're using lies to keep you in a situation against your free will. Other forms of deception may include, for example, lying to workers about their conditions of work. So someone says, oh, if you come to Thailand, I will give you a good job with a high salary. And then when the worker arrives, it turns out that their conditions are much different to what they've actually been promised. That's a form of fraud and deception. Then we have the abuse of power or position of vulnerability. So here we're talking about someone who has authority over another person. So let's say a teacher over a student, or a parent over their children, or a government official over an ordinary person, where a person abuses their authority as a way of putting someone in a situation of exploitation. That can be a means under the Palermo Protocol. And the last one, rather long, but the giving or receiving of payments to another person to gain control over another person. And here what we're really talking about is, say, for example, someone going to the parents of a child, say, and giving the parents money to take the child away. So, for example, someone may come to a poor family, or a family may even sell their child to someone else. And that's what we're really talking about under that means element. Now, I'll come back to this last point about not having to prove the means element for children, but just bear that in mind for now. So the third and final element of the definition of trafficking is the purpose. And what we mean by this is human trafficking under international law, but also under Thai law, is a crime of intention. You can't accidentally commit human trafficking. You can't commit human trafficking by negligence. You have to intend to commit the crime. And so the purpose describes the intention of the perpetrator of the crime. So the purpose is exploitation. So the perpetrator must act with the intent of exploiting the victim. And the Palermo Protocol does not actually define what exploitation is. It just gives a list of examples. So exploitation includes exploiting someone for prostitution or sexual exploitation. It includes forced labor. It includes slavery, servitude, and the removal of organs. So these things constitute exploitation, but that's not all that exploitation could be. So for example, one thing that's not mentioned here is the production of pornography. That could be a form of exploitation. Or for example, to force a child to beg or to commit crimes. That could be a form of exploitation. And so it's important again to think about the concept of exploitation in broad terms. What's most important to remember about exploitation is that it doesn't matter if the victim appears to consent. So the fact that someone agreed to work or agreed to accept a job doesn't mean that they're not being exploited. You can still be exploited even if you apparently agreed to the work or to whatever it is that's being done. And this is because, remember, going back to the means, where there are the means, the victim's ability to freely give their consent and to voluntarily perform whatever it is they're being asked to do is taken away from them. So if I lie to someone in order to get them to agree to perform work for me, then that consent is not real and that consent is not genuine. And that's why when we're thinking about whether someone is a victim of exploitation, we don't think about whether or not they gave their consent. That's not a relevant consideration. Now, the other thing to know about the purpose is that we're looking at the subjective intention of the perpetrator. So what did the perpetrator intend to do? So it doesn't matter if the victim is not actually exploited. If the perpetrator intended to exploit the victim, then that's good enough. So the first two elements are concerned with what was done and how it was done. And the third element is concerned with what was the perpetrator thinking when they did that thing. Now, all three elements have to be there together in order for something to be considered human trafficking, if the victim is an adult. If the victim is a child, we don't have to worry about the second element. We don't care about the means. And this is because a child doesn't have the ability under law to give their informed consent because they're a minor. And so we don't have to worry about these means taking away the free will and the ability to consent because a child automatically doesn't have the ability to give that consent. So if the victim is a child, we only have to think about the first element, the act, and the third element, the purpose. So we don't think about the means. So it's actually quite a low threshold to prove human trafficking in the case of a child. So I hope that's clear, and we'll have a chance to apply this definition and think about it in a little bit more detail in the exercise, which we'll do after this. So I also want to highlight as well that in addition to the Palermo Protocol, there are a few regional legal instruments that also govern human trafficking. And there are a few that are highlighted there on the screen. So the Palermo Protocol is not the only international legal document that relates to human trafficking that might be relevant to your work. In Thailand, the most important one to know about is the ASEAN Convention Against Trafficking in Persons, which deals with human trafficking in the ASEAN region, and Thailand is a party to that document. The definition of human trafficking under the ASEAN Convention is the same, essentially, as the Palermo Protocol. So I don't need to go into it in too much detail here. It's just important to be aware that this ASEAN Convention exists, because you may come across it in your daily work, particularly if you work with ASEAN bodies and with ASEAN organizations. Okay, so the second topic, the second crime I want to cover is the crime of migrant smuggling. And migrant smuggling often gets confused with human trafficking, but they are most certainly not the same thing. So migrant smuggling is defined under the Migrant Smuggling Protocol, which was actually written at the same time as the Palermo Protocol. It is also a UN treaty. And migrant smuggling is defined as the procurement in order to obtain directly or indirectly a financial or other material benefit of the illegal entry of a person into a state of which that person is not a national or permanent resident. So, breaking that definition down, migrant smuggling involves three things. First, procuring the illegal entry of a person into a country of which that person is not a citizen or permanent resident for the purpose of obtaining a financial or other material benefit. So, unlike human trafficking, and this is something I forgot to mention earlier, you'll notice that in the definition of human trafficking, it doesn't say anything about crossing a border. So there's nothing international about the crime of human trafficking. Human trafficking can occur entirely within one country. Whereas migrant smuggling requires someone to cross a national border, so to enter a country illegally. So already one of the key distinguishing features between migrant smuggling and human trafficking is that migrant smuggling requires someone to move across a national border. The second thing that's required is that the moving across a national border has to be illegal. So it can't be under a visa or it can't be through regular migration channels. Whereas with human trafficking, very often, human trafficking actually occurs through legal migration channels. People may come in through work visas or on tourist visas or visa-free entry schemes. So you don't have to enter a country illegally in order for a situation to be considered human trafficking. Whereas with migrant smuggling, it must be illegal entry. And the third thing is that the victim, the perpetrator of migrant smuggling, must act for the purpose of obtaining some kind of financial or material benefit, right? So unlike human trafficking, where the perpetrator's intention is to exploit the victim, in migrant smuggling, the perpetrator's intention is to gain some kind of financial or material benefit. They're doing it for financial gain. Now, the other thing to note is that whereas human trafficking is a crime
ก็
against
คือว่าในฐานะที่เรื่องของการค้ามนุษย์เนี่ยมันเป็นอาชญากรรมกับต่อมนุษย์ แต่ว่าการลักลอบขนผู้โยกย้ายถิ่นเนี่ยเป็นอาญานะคะในระดับชาติก็คือคนที่ถูกโยกย้ายถิ่นฐานหรือถูกลักลอบเข้ามาเป็นคนที่ตกเป็นผู้ที่ถูกกระทำแต่ว่าอาจจะไม่ได้เป็นผู้เสียหายก็ได้นะคะแต่ว่าถ้าเป็นการค้ามนุษย์นั้นคนนั้นจะตกเป็นผู้เสียหายหรือเป็น victim ทันทีครับสิ่งที่ค่อนข้างยาก
of migrant smuggling can sometimes blur and actually transform into situations of human trafficking. So, for example, a human trafficker might pretend to be a migrant smuggler in order to gain access to victims. So, a human trafficker might go to someone who's looking to enter Thailand to do some work, and the person pays the smuggler to get them into Thailand so they can find a job. But instead, the migrant smuggler sells the person to a brothel or to a fishing boat or to a factory. And so then the situation turns into a situation of human trafficking. Or alternatively, someone might pay a migrant smuggler to enter a country or to leave a country, But once they arrive, that person is then, because they may be in a vulnerable situation, they may then be exploited by other people, or they may be deceived. And then their situation turns into a situation of human trafficking. So while in practice, migrant smuggling and human trafficking are very different things, in practice, situations of migrant smuggling can often evolve into and become human trafficking. But it's important to look at each of the definitions separately and understand the distinctions between them when looking at cases to decide whether this is migrant smuggling or this is human trafficking. Okay. The next international crime that I want to touch on is forced labor. And again, you may remember that forced labor is actually one of the purposes of exploitation. So forced labor is actually a form of exploitation within the definition of human trafficking. But forced labor is also a crime in its own right. And the crime of forced labor is actually, under international law, much older than the crime of human trafficking. So the crime of forced labor was first codified in international law under the ILO 1930 Forced Labor Convention, whereas the Palermo Protocol didn't come into force until nearly 70 years later. So forced labor is a much older crime and predates human trafficking by several years. Although under Thai law, it's the opposite. The crime of human trafficking has existed for much longer than the crime of forced labor, which only recently was introduced into Thai law. But we'll cover that next week. So there are two key international treaties on forced labor. The first is the ILO 1930 Forced Labor Convention, and the second is the 2014 Protocol to the Forced Labor Convention. But the definition of forced labor comes from the 1930 Convention. So forced labor is defined as all work or service which is exacted from a person under the menace of any penalty for which the person did not offer themselves voluntarily. So that definition can be broken down into two parts, right? Work or service under the menace of a penalty. And the second part, for which the person did not offer themselves voluntarily. So work and service is interpreted very broadly. It can involve any kind of work or service. It doesn't have to be paid. It doesn't have to be legal. And it doesn't necessarily have to involve a traditional profession or job. So for example, sexual services are a form of work or service. If someone forces children to beg or to sell garlands on the side of the road, that is a form of work or service. So we have to interpret that very broadly. The work or service also has to be performed under the menace of a penalty. So what that means is we're not just talking about punishments or criminal penalties. We're talking about any kind of threats, intimidation, coercion, violence, threats of the loss of opportunities or benefits. So menace of penalty should be interpreted very broadly. And again, similar things to what I described before when I mentioned coercion. So intimidation, passport retention, threats to report someone to the authorities for being an illegal worker or an illegal migrant. Those could all be a menace of a penalty. And the other important thing to note is the work is performed under the menace of a penalty, so the threat of a penalty. They don't actually have to apply the penalty, as long as there's a clear threat to impose the penalty or the punishment on the worker. And the second element of the forced labor definition is that the worker must not offer themselves voluntarily. So voluntary work means that a person gives
ส
their
มัครใจทำงานแปลว่า
informed consent to do the work.
แล้วก็เขารับรู้อยู่ว่างานนั้นที่จะทำอะไรนี่คือความสมัครใจ ขอโทษทีมีคำถามที่ถามผมมานะคะว่ามีเสียงในสำหรับใครที่กำลังฟังการแปล
says mute original
มีเสียงที่ว่า mute original audio นะครับถ้าคลิกต้องการฟังแต่ภาษาไทยชัดเจนให้คลิกคำว่า mute original audio เพื่อให้มันจะได้ไม่มีฟีดแบ็กจากเสียงในห้องรวมนะครับเอาล่ะแปลว่าไม่ได้สมัคร
right so the
ก็
consent
สมัครใจก็แปลว่าเขายอมมาการยินยอมเนี่ยหลอกมาก็ไม่ได้หรือทำอะไรที่เป็นแบบรับลวงพรางก็ไม่ได้นะคะอันนี้มันไม่ใช่
so just because I agreed to take up a job
ยอม
doesn't
ที่
mean
จะทำงานแล้วก็ทำงานก็ไม่ได้แปลว่าผมจะอยู่ตลอดกาลถูกไหมครับถ้าคุณไม่สามารถที่จะออกจากงานนั้นคุณก็ไม่ต้องสนใจนะว่าคุณตกลงมาทำงานนั้นแต่แรกหรือเปล่าแต่ถ้าคุณถูกบังคับให้อยู่ต่อนะครับมันก็เลยจะกลายเป็นแรงงานบังคับได้เพื่อที่จะคุณจะต้องรู้ว่าสถานการณ์คืออะไรมีการข่มขู่หรือไม่แล้วก็มีการกำหนดว่าจะลงโทษหรือขู่ว่าจะลงโทษหรือไม่อันนี้ก็คือเรื่องของแรงงานบังคับซึ่งเดี๋ยวผมจะพูดรายละเอียดเพิ่มเติมขึ้นมาแล้วก็อันนี้มีคำถามที่ดีมากคุณลินซี่ถามนะคะในแง่ของเดี๋ยวผมก็จะพูดถึงเรื่องนี้พอดีคือมีบางเรื่องที่ไม่ได้รับที่เรียกว่าไม่
5 different types of activity that do not amount to forced labor
มีการกำหนดอยู่การกระทำ5อย่างที่ไม่ใช่เป็นแรงงานบังคับอย่างแรกสุดนะคะสำหรับคนที่ถามมาใน
labor
คนไทยที่ถามที่นะคะการบังคับเกณฑ์ทหารไม่ได้ถือเป็นแรงงานบังคับนะครับอีก4เรื่องนี้อาจจะเข้าใจที่ยากนิดนึงก็คือการหน้าที่ปกติ
Some countries either in addition to military service or instead of military service they might require citizens to do civil service so Germany used to have this where you wouldn't necessarily join the army but you might become a teacher for a year that's what that exception is looking at. Then we have work or service as a consequence of a criminal conviction, but importantly, not if the work is being done for a private enterprise or for commercial gain. And for those of you who have been following the news in Thailand, you will know there has been a very recent scandal about prison labor in Thailand. And so while it is possible to legally sentence someone to perform labor as a punishment, if that labor is being done for a commercial purpose, or if prisoners are being sent to work for private corporations, then that's not allowed under the Forced Labor Convention. That is forced labor. The other two are communal services. So these are slightly different to civic services, but not really relevant in the Thai context. And then the last one is worker services in cases of national emergency. So again, let's say that there is some kind of serious emergency that
พิบัติฉุกเฉินขึ้นมาแล้วก็ชีวิตแล้วก็
then the government can in those circumstances force people to work and that would not amount to forced labor. But for our purposes these days, really the two that are perhaps the most relevant are military service and also prison labor or work as a result of criminal convictions. Those are the two exceptions that most commonly we'll see in real life. Now, I do want to move on to the exercise, so I will skip over child labor, but you do have the slides in English and Thai to look at that yourselves. The last form of exploitation I want to cover here is slavery. So slavery is what many people consider to be the ultimate form of exploitation. But in fact, in modern times, slavery, at least the way it's defined in international law, is quite rare. So the key distinguishing feature of slavery compared to the other forms of exploitation we've looked at is that slavery involves treating another human being as if they are property. So asserting a right of ownership over another human being is what is the distinguishing feature of slavery. And that is set out in the 1926 Slavery Convention and 1956 Supplementary Convention on Slavery. And actually, Thailand is not a party to either of the slavery conventions. Unlike the other instruments we've looked at before, Thailand is a party to the Palermo Protocol and the 1934 Slavery Convention, but it is not. Okay, so lastly, I just want to try and situate these international legal instruments within a broader framework of documents and instruments and legal rights. So human trafficking is really just one element of the various rights and legal instruments and laws that may be engaged where someone is in a situation of trafficking or exploitation. So the Palermo Protocol and the crime of human trafficking did not really come from the human rights law system. It's a criminal law document. But as we'll cover in the second part of this training, victims of trafficking have a wide range of rights, human rights, labor rights, and other civil rights that are also relevant. And so it's important to remember that while the documents that I've talked about before, the Palermo Protocol, the Forced Labor Convention, are very important, they're not the only thing that we need to bear in mind. We need to think about criminal law instruments, we need to think about human rights law instruments, refugee law instruments, labor rights, the rights of migrants, and both under national and regional and international law. So we have to take a very holistic picture when thinking about the different rights of victims and not just think about it from the narrow lens of the one or two legal documents that I just talked about. So I will pause there because what I'd like to do now is go into a little exercise where we will look at some case studies to apply these different definitions, which I've just covered. So in a moment, I'm going to divide all of you up into three groups. Those that speak English will stay here in the main group with me. And then those that speak Thai will be split up into two breakout groups, which will be led by facilitators in each of the groups. And I will give you about 15 minutes to together in your groups, look at the facts of a case study, and then discuss amongst yourselves whether you think that this is a situation of human trafficking or forced labor or possibly some other kind of offense. And then at the end of the 15 minutes, we'll come back together and then someone from your groups will present your answers to the rest of the groups. And if you have any questions or if you're not sure, the facilitators in your breakout groups will help guide you through the activity. And I will also be ducking into each of the breakout groups to make sure you're on the right track and see if you have any questions. If you get put into a breakout group that is speaking Thai, but you don't speak Thai, just leave the group and come back into the main room where we'll be speaking English. So Ryan, if you want to go ahead and please open the breakout groups and split everyone up.
วัสดีค่ะทุกคนขวัญนะคะขวัญเป็นโปรแกรม Manager นะคะสำหรับโครงการ USAID Asia Counter Trafficking in Persons นะคะขวัญจะเป็น Facilitator ให้กับกิจกรรมในครั้งนี้นะคะซึ่งเราจะใช้เวลาประมาณ15นาทีด้วยกันนะคะช่วยกันอ่านเคสแล้วก็ในระหว่างที่อ่านเนี่ยเราจะมีเวลาประมาณ5นาทีนะคะเดี๋ยวขวัญจะจับเวลาไว้แล้วก็ในที่ระหว่างที่อ่านเนี่ยเราก็จะช่วยกันตอบคำถามหลังจากอ่านเสร็จนะคะเราจะช่วยกันตอบคำถามในระหว่างอ่านเนี่ยอาจจะพิจารณาไปด้วยว่าเคสนี้เนี่ยมีคิดว่าเป็นสถานการณ์การค้ามนุษย์หรือเปล่ามีเหตุการณ์การบังคับใช้แรงงานเข้ามาเกี่ยวข้องไหมหรือว่ามีอาชญากรรมใดอื่นๆอีกที่เข้ามาเกี่ยวข้องนะคะเพราะฉะนั้นเดี๋ยวขวัญแล้วก็หลังจากนั้นเนี่ยขวัญจะขออนุญาตนะคะขออาสาสมัคร1คนค่ะที่จะไปพรีเซนต์คำตอบของกลุ่มเรานะคะให้ในห้องเมนรูมถ้าอย่างนั้นแล้วเนี่ยเดี๋ยวขวัญจะขออนุญาตแชร์สกรีนเลยนะคะสำหรับเคสทีมเราได้เคสที่2นะคะสักครู่ค่ะทุกคนเห็นสกรีนขวัญไหมคะ
เห็นค่ะ
โอเคค่ะถ้างั้นขวัญจะมิวตัวเองนะคะแล้วเดี๋ยวอีก5นาทีขวัญจะกลับมาพูดคุยกันค่ะเดี๋ยวระหว่างนี้ขวัญจะแชร์คำถามในแชทด้วยนะคะเรามีเวลา5นาทีในการอ่านกรณีนี้ค่ะเชิญค่ะ เหลืออีก1 นาทีนะคะโอเคค่ะไม่ทราบว่าอ่านกันเสร็จกันหรือยังคะ
เสร็จแล้วค่ะ
โอเคขอบคุณค่ะงั้นเดี๋ยว stop share เนาะแล้วเดี๋ยวขวัญจะได้แชร์คำถามร่วมกันในแชทค่ะเดี๋ยวแป๊บนึงนะคะวันนี้คนตอบแล้วเร็วมาก สักครู่นะคะคำถามหลักๆที่เราจะคุยกันก็คือคิดว่าเคสนี้เนี่ยเป็นเคสค้ามนุษย์หรือไม่เพราะเหตุใดคะทุกคนมีผู้ตอบมานะคะว่าคุณชาวลิตนะคะขวัญขอโทษนะคะถ้าเกิดขวัญเอาเสียงผิดชัดเจนว่าเป็นการค้ามนุษย์ค่ะเพราะว่าจากพฤติกรรมของเวียงที่ส่งและขายเมย์ต่อให้นายหน้านายวิทยพลอีกทั้งยังถูกบังคับให้ขายบริการทางเพศคนอื่นเห็นด้วยไหมคะ
เห็นด้วยค่ะ
โอ้มีคนเห็นด้วยหลายคนเลยค่ะจากสาเหตุอะไรบ้างนะคะก็คือมีการขนย้ายชัดเจนมีการหลอกลวงใช่ไหมคะแล้วมีอะไรเพิ่มเติมไหมคะ
แล้วก็มีในส่วนของค่าแรงที่ทำงานแล้วน้องก็ไม่ได้ค่าแรงด้วยนะคะเพราะไม่ได้รับเงินด้วยในโจทย์
ใช่ค่ะถูกต้อง
มีเรื่องของการข่มขู่แล้วก็ในเรื่องของการโดนลงโทษอะไรอย่างเงี้ยค่ะด้วย
ใช่แล้วก็ในเคสไม่ได้ระบุว่ามีการยึดเอกสารหรือเปล่าแต่ว่าเหมือนจะอนุมานได้เลยใช่ไหมคะว่าเพราะว่าเขากลัวตำรวจหรืออะไรก็ตามแต่เนี่ยก็จะเป็นไปได้ว่าเขาถูกยึดเอกสารไปด้วยต่อไปนะ
แต่
คะ
ทีนี้มีคำถามนะคะอันนี้ไม่แน่ใจว่าจะตอบกันในกลุ่มเล็กเลยไหมแต่จริงๆแล้วคือมันดูเหมือนว่าเป็นได้ทั้ง2เคสถูกไหมคะหมายถึงว่ามันเป็นได้ทั้งค้ามนุษย์แล้วก็ในเรื่องของแรงงานบังคับด้วยค่ะหมายถึงว่าแต่ละเคสที่มันสามารถจะเป็นได้ทั้ง2อย่างถูกไหมคะ
ใช่ค่ะเนี่ยค่ะก็จะนำมาสู่คำถามต่อไปนะคะว่านี่เลยคุณคิดว่ากรณีนี้เนี่ยเป็นการบังคับใช้แรงงานด้วยหรือไม่เพราะเหตุใด
ใช่เพราะว่านี้มองว่าก็เป็นค่ะเพราะว่ามีเอลิเมนต์ในเรื่องของว่าเขาจะต้องทำงานโดยที่โดนข่มขู่ให้ทำงานแล้วก็อย่างที่2ก็คือในเรื่องของความยินยอมอะค่ะคือเขาไม่สามารถที่จะไม่ทำได้แล้วก็ไม่สามารถที่จะไปจากสถานที่นี้ได้ค่ะ
ใช่ค่ะเห็นด้วยมีคนอื่นเห็นด้วยไหมคะหรือว่าเห็นแย้งหรือว่าเพิ่มเติมในส่วนไหนไหมคะใช่ไหมคะ
เห็น
ทุกค
ด้วย
เห็น
ค่ะ เพราะว่าเขาไม่ได้รับค่าจ้างแล้วก็ถูกข่มขู่แล้วก็ไม่แน่ใจอีกประเด็นหนึ่งที่คนแรกที่พาลักลอบมาขายแรงงานในไทยด้วยอย่างเงี้ยค่ะลักลอบขนแรงงานข้ามชาติ
ใช่ขอบคุณค่ะถ้างั้นทุกคนค่อนข้างเห็นไปในทิศทางเดียวกันหมดนะคะมาสู่คำถามสุดท้ายนะคะว่านะคะขออนุญาตแชร์คุณคิดว่าอาจมีการก่ออาชญากรรมอะไรอีกบ้างนอกเหนือจากการค้ามนุษย์แล้วก็การบังคับใช้แรงงานที่เราพูดกันไปหรือเปล่านะคะเช่นการลักลอบขนผู้ยกย้ายถิ่นฐานแรงงานทาสหรือแรงงานเด็กรวมด้วยหรือเปล่า
ในเรื่องของการลักลอบขนแรงงานข้ามชาติค่ะแล้วก็บังคับค้าประเวณีค่ะ
ขอบคุณค่ะคุณคิดว่าคนที่เกี่ยวข้องโดยตรงกับ ขนลักลอบขนผู้ยกย้ายน่าจะเป็นคุณเวียงใช่ไหมคะที่มีหน้าที่ขนศพที่ค่ะเห็นด้วยเช่นเดียวกันค่ะมีใครมีอะไรเพิ่มเติมไหมคะถ้าทุกคนเห็นพ้องต้องกันหมดเนี่ยก็แสดงว่ากลุ่มเราต่อไปในทิศทางเดียวกันหมดนะคะก่อนที่เราจะหมดเวลาเราจะกลับไปในห้องใหญ่ขออาสาสมัครหนึ่งท่านได้ไหมคะในการที่จะไปตอบคำถามรวมถึงบอกเหตุผลประกอบในห้องใหญ่มีใครสนใจไหมคะเดี๋ยวขวัญแชร์คำถามอีก3 ข้อให้อีกรอบหนึ่งในแชทค่ะมีคนสนใจไหมคะหรือสามารถถ้าจะมากกว่า1 คนเป็น2 คนช่วยกันตอบก็ได้นะคะนี่ค่ะขวัญรวบรวมคำถามให้ที่สามารถไปตอบได้ในห้องใหญ่ไหมคะถ้าไม่อย่างนั้นขวัญคุณการมณีสนใจไหมคะขวัญ
ได้ค่ะได้เลยค่ะ
ขอบคุณค่ะมีคนจะช่วยคุณการมณีตอบไหมคะหรือว่าคุณการมณีสะดวกตอบทั้ง3 ข้อไหมคะ
ถ้าไม่มีท่านอื่นก็ตอบได้ค่ะ
ขอบคุณมากค่ะถ้าอย่างนั้นเราสามารถ leave room นี้แล้วก็ไปรวมกันที่ห้องใหญ่ได้เลยนะคะแล้วเดี๋ยวเราก็ไปรอคุณการมณีพรีเซนต์คำตอบในห้องใหญ่ค่ะขอบคุณทุกคนมากๆเลยนะคะ
Looking at the same situation again, does anyone think that this is a situation of forced labor? And I'd be happy to hear from the same person, or if anyone else wants to express an opinion about whether they think SOC is a victim of forced labor.
I think this is one of the thing is included under the forced labor. I mean, if you are seizing the document, is one of the things. So it is go under the title of forced labor already.
Okay. So what are some specific things that you can point to that suggest that this is forced labor?
I think
seizing the document. You know, the manager is taking away the document from the Mr. So.
Mm-hmm. Yeah, great. So we have document retention, and someone else was trying to say something. Please go ahead.
Yeah, sorry, I didn't realize someone else. Which ones are perfect? So, one thing I wanted to clarify is that is this a typo which says he can leave the construction site?
No, that is correct. He can leave. Yeah.
He can leave. Okay. So at least the isolation bit would be a bit difficult to prove there if he can leave. But also there is there's thing of identity. There are
Yeah, sorry, I didn't quite catch that because you were breaking up, but I think what you're trying to say is the fact that he can come and go freely from the work site might make it hard to prove that this is a situation of forced labor. And again, this is actually a difficult situation because the fact that someone is free to come and go doesn't mean that they're not free to leave their job. So what we're concerned about is the fact that he's not voluntarily working, whether or not he can still leave. Now, the fact he can physically leave may suggest he's working voluntarily, but we have to weigh that against the evidence that goes the other way, like debt bondage, like the lack of a passport. And then we have to make a decision about, well, looking at this in the round, can we say that he is voluntarily working or has the freedom to refuse to keep working? And yeah, I think that you highlighted that well. I think on balance, in this situation, we would lean towards saying, although he can physically come and go, he can't leave his job, and therefore he's not voluntarily working. But arguments go both ways. This is not a clear-cut situation. Okay, and yes, as you point out, many ILO indicators of forced labor are present in this situation: document retention, deception, salary deduction, excessive working hours, etc. So very good as well, Siti. Thank you. Okay, so sorry, you wanted to mention something else.
Oh no, I was just asking whether someone like Sok in this situation would have to raise concerns with their employer, like pointing out like arguing for shorter working days. Would they have to do that before and have that refused before they could then take that further?
No, because it's a good point you raise, and again, something that people will point to. Well, you never complained. But as we know, workers, and especially migrant workers, are often very ill-informed about their rights, and particularly where there is elements of deception involved. The fact that the worker doesn't know or isn't in a position to advocate for their rights because they're in a vulnerable position. We know he was afraid to speak up about the fact the contract is in Thai because he didn't want to not get the job. So all of these things will often mean that people don't speak up, or many people will not recognize that they are victims. So in situations of sexual exploitation, where there's grooming and those kinds of behaviors, it can sometimes be difficult for people to recognize their own status as having been exploited. And so for that reason, again, if we remember the consent of the person is not relevant to whether we think there's exploitation. In the same way, certainly the fact that someone didn't raise a complaint is something to weigh in the balance, but often not given a lot of weight when weighed against the information asymmetries and the power imbalances and the lack of understanding about rights.
I meant, sorry, I meant more sort of like, I understand completely ethically why that shouldn't be a consideration. I meant more from the point of view of the construction site manager in this point of view. If he was making a legal case, I mean, all of the way this is worded here is that this man is frightened of all these things, but not necessarily that he has had this confirmed to him by his employer, any of his fears. So exactly. I guess what I meant is legally, would Mr. Beng have actually had to make these things clear himself for it to be counted as intent or purpose from his point of view? Yeah,
that's a great point. And again, in the defense of the construction site manager to a trafficking charge, then definitely he could say, I had no intent to exploit because I didn't know about all these things. In a forced labor charge, because the intention is actually not relevant in a forced labor charge. So, there is no purpose element involved in the forced labor definition. So as long as there's evidence that there was work done under a penalty and it wasn't voluntary, that's forced labor. So definitely could be a counter argument, probably going to be weaker in the context of trafficking in forced labor compared to trafficking. Unfortunately, we could go on for hours about this, but I think I will need to move on. So I will ask all of the breakout rooms to rejoin us. And then if Asravi, if you want to attempt to consolidate some of our responses to those questions, and we'll see how we go.
Thanks.
So everyone will come back in about 60 seconds. Okay, so hopefully we should all now be back together. I hope you found that discussion useful and interesting. I'd like to call on one representative from each of the groups to give an answer to one of the three questions, just in the interests of time. So very selfishly, I will ask.
Sorry, Navin, can you wait a bit? I'm waiting for the Thai interpreter to start.
Oh,
Just a
sorry,
moment, please.
Sure.
โอเคขออภัยไม่ได้เปิดไมโครโฟนนะคะ
โอเคค่ะพร้อมนะคะ
พร้อมแล้วนะคะ
โอเคค่ะงั้นเดี๋ยวขอบอกให้นาวินสตาร์ทได้เลยค่ะขอบคุณค่ะ
Thanks, Kwan.
Okay, Navin, you can start.
Okay, so I hope you found that discussion interesting and useful.
ในเรื่องของการพูดคุยนั้นจะมีประโยชน์มากทีเดียวนะคะเรามี case study เป็นกรณี
You know, both of them could go, there are good arguments either way. So I'd be interested to see what you came up with. I would like to call upon my group first, the representative of group one. If you could very briefly give a summary of the facts of our case study and then explain our view about whether this is human trafficking or forced labor. So it don't have to read out all the details, just a really quick summary.
Okay, thanks. Can you hear me well?
Yes.
Okay, so a quick summary would be that this person has been recruited from Cambodia to work in Thailand. He's not a minor. There's a recruitment fee that was charged. He thought that he would be earning much more than what he actually ended up earning. There was no contract that was signed before he left. The contract was given to him after he reached the destination, but it was in a language that he didn't understand. He still signed it anyway. And the amount that he received was lower than what he was expecting. It was communicated to him that the deduction in wages is because of the accommodation and food charges that are being provided in the dormitory setting that the employer maintains. He also worked about 12 hours a day without taking days off and without any breaks, regular breaks in between. So that's it in brief. Then we talked about whether the situation could be a potential situation of trafficking. So we discussed. Start message. No. Okay. So we discussed about whether it could be a potential case of trafficking or not. In this case, we were discussing elements under the Act and purpose definition under the Palermo Protocol. So first we discussed about the recruiter, and it's difficult conclusively say either way in this case because we don't have too many facts, and there might be arguments on both sides. So when it comes to the recruiter was involved in the transportation of the person. So that is there, but also the recruiter might not be benefiting from the exploitation of the person.
ประโยชน์อะไรจากการที่จะเอาคนนี้มาอาจจะเป็นว่าเขาจะได้ในเรื่องของการที่จะเก็บค่าในหน้า
which is to take out the fact that there shouldn't be any recruitment fee and related costs when it comes to migration, but then we can't conclusively say that the recruiter was benefiting from the exploitation or was possibly involved in the deception or fraud that happened. He could or could not have been. So, but those are arguments to think about later. And then when it comes to the employers, so when it comes to act, so the employer was harboring this person. When it comes to several elements of deception and coercion, so the contract was in a language, as I mentioned, that this person couldn't understand. There was deduction of salary. There was withholding of identity documents. So he could have left even if he wanted. And when it comes to purpose, the employer knows that Sok is in a vulnerable position. He can't understand the language. He doesn't have valid identity documents, and he's forced to work for excessive hours. So that is something where we can try to prove all three elements, but we also discussed it from the side of the factory owner and the arguments of the factory owner, that where say that my intention was not to exploit, because and one of the things that could come up is that no complaints were made by the person. So that could be one of the things that the factory owner can say that I wasn't aware, or it wasn't my intention. We'll probably need more information to decide on that. Then when it comes to forced labor, we discussed the ILO indicators of forced labor, and there was general consensus that most of the ILO elements are met in this case. So there was excessive overtime, debt, document retention, salary reduction. And we also talked about the fact that he was allowed to leave after finishing work, but then also that doesn't mean physically being able to leave the premises, that he can voluntarily leave the job, because he also had a debt and he didn't have access to his passport.
Great, thanks very much.
Yeah.
Okay, I want to move quickly on to group 2. If someone from group 2 would like to answer just the answer to question number 2. So did you think your case was a situation of forced labor? And if so, why? So again, if you just want to very quickly summarize the facts of your case and then give your group's answer to question 2. Do you think this is a situation of forced labor?
Hey, okay. So in the second case, we're talking about May, who's a 19-year-old from Laos, and basically she's been recruited by her cousin, who say that they could get her a job in Vientiane, but so the parents say yes, but she was not transported to Vientiane, but actually she was sold to a recruiter, and then the recruiter brought her to work in a hotel in Bangkok, which is more like a brothel. So basically it was a forced prostitution. She was forced to work, and she was abused, and she was not paid. She only received certain allowance, and also she was threatened that if she would escape or talk to the police, then her parents will be in danger. So she's afraid she'll have to continue working because she's afraid to get arrested or putting her family in danger. So to answer the second question on whether this is a forced labor case, there's an element of working under the menace of penalty, because she's afraid of getting arrested, and also she's afraid for her parents'
หรือ
safety.
เกรงว่าครอบครัวของเธอจะตกอยู่ในความเสี่ยงอันตรายก็มีองค์ประกอบเกี่ยวกับเรื่องของการไม่สมยอมการไม่ยินยอม
Free to make that the decision whether she wants to work or not, and also there's no consent because she didn't agree to do this job. She was told she was going to be doing a different job, and she cannot leave this work. So that's just to summarize it quickly.
Great, thank you very much. Group 3, let's look at the case of Ploy. Again, if someone wants to offer a summary, and then why don't we talk about whether you think this is human trafficking?
Yes, so for the case, it's about the Ploy, who is a 14-year-old girl, and she met a friend through Facebook, whose name is Chai. She knew him as a 20-year-old man, and they started talking, and they started to getting closer, and Chai was talking to her more and sexually interested, and he asked Ploy to come and meet him and for her to be his model. She agreed, but when they actually met, it turns out that Chai is not a 20-year-old boy, but a 40-year-old man, and they were in a situation where Chai forced Ploy to take off her clothes, and he took photos of her, and he also that was posted online as a video online. And after that was done, Chai paid Ploy 5,000 baht and told her that to keep this story a secret, because if not, they both are going to be in big problem. So Ploy never told anybody about what happened, but many months later, Ploy's parents found out about their chat story, so they report that to the police. And so after our discussion, we agreed that this is the trafficking case, because first of all, considering the age of the Ploy, she is still a minor, and Chai was obviously trying to deceive and to lure her to do what he wants, and he threatened her to do what he wants to.
Yeah, great. So again, this one's an interesting one because there's no movement, right? The victim doesn't go anywhere; she stays in one place, and there's no international elements involved here. But yet, if we think about the elements, there's recruitment, there's exploitation, right? The production of pornography. So he's obviously exploiting her. And even though the victim is a minor, we don't have to prove the means. There is obviously clearly deception and also some intimidation going on here as well. Just to illustrate that trafficking can take many different forms, and it doesn't necessarily involve what we typically consider moving people from place to place. So great, I hope you found those discussions useful, and I have shared the exercises and case studies with the chat if anyone would like to keep them for future reference. I will also say now, before I forget, that this whole training is actually available in a video on the Freedom Collaborative website. So I will ask one of our colleagues to share the link to this training as a recording with the chat so that you can watch it later. And actually the recording is a little bit longer and goes into these topics in a little bit more detail. It's only available in Thai though, unfortunately, but if anyone wants to look at this later, there is a recording available. Okay, so now I want to pick up on the second part of our training and move on to part 2. One moment. Okay, I hope you can all see my slides. So in the last 30 minutes we have available, I want to very quickly run through some of the key principles that underpin everything we do when we work on trafficking cases and work with victims of trafficking. If there are people here from IJM, IJM run a great training on trauma-informed approaches to working with victims of trafficking. My intention is not to try and cover all of that here. We would need a whole nother training session. What I really want to talk about is to just cover some really high-level principles that you may have heard about before to explain what they mean and how they may apply in a trafficking context. Because as I said, these principles really inform everything we do when we work on trafficking cases. So the first thing, the first and perhaps most fundamental principle is what we call the human rights-based and victim-centric approach. And you may have heard of this phrase before. And what do we mean by this? Well, according to the UN, the human rights and victim-centric approach really means that the human rights of victims of trafficking should be at the center of everything we do to combat trafficking and to protect, assist, and provide redress to victims, right? So we have to put the human rights of the victim at the center of everything we do. Because historically, we have often looked at human trafficking from a law enforcement lens. Right? We are focused on prosecuting offenders. We are focused on identifying victims. We are focused on breaking trafficking rings. And we forget that actually the reason for doing all this is because there is a victim who has been exploited. And so the victim-centric approach really says, well, instead of focusing on combating crime, punishing perpetrators, we should focus first and foremost on realizing the human rights of the victim of trafficking. And that really involves 4 key things. The first, obviously, is making the human rights of the victim the most important thing in everything we do. The second thing is to not only look at fighting the crime of trafficking, but also to look at the root causes of trafficking. So why are people being exploited? So lack of economic opportunities, education, gender inequality.
มาเป็นในเรื่องของอะไรความเสมอภาคในเรื่องของการศึกษาในเรื่องของความไม่เท่าเทียมทางเศรษฐกิจหรือไม่
Situations of exploitation. We also have to look at treating criminals as persons in need of protection and assistance and not prosecuting. And then, of course, as well, the punishment of perpetrators and providing redress and compensation to victims for their rights violations. But punishment is really just part of a victim-centric approach. It's not the main focus of our approach. So this really involves a few, one way in which we can conceptualize a victim-centric approach is to think about the victim as being someone who has a whole range of different rights: human rights, civil rights, family rights, rights under criminal laws, rights under labor laws, rights under contracts. And it's our job when working with victims to protect and vindicate and help victims realize all of these diverse rights. The victim is not just a passive subject in our criminal investigation that gets dragged along. The victim should really be the primary focus of all of our efforts. And in addition to making sure that we do everything we can to put the victim's rights at the center of all of our efforts, the victim-centric approach also means that we don't do anything when we're working with victims that might undermine or harm those rights. And this is what we mean by what we call the do no harm principle. And so what we mean here is that anything we do when we're working on a trafficking case should not harm the human rights or human dignity of persons. In particular, the rights of people who have been trafficked, but not just the rights of people who have been trafficked, because perpetrators have rights too. They have the right to a fair trial. They have the right to due process. And so while we often talk about do no harm to victims and respecting the rights of victims, it's important to remember that everyone involved in a trafficking case, including the perpetrator, also has human rights that need to be respected in our work and what we do. So do no harm really means that we do nothing that could adversely affect the physical, psychological, material, emotional safety and well-being of victims and not undermine their human rights and human dignity. And that includes, for example, taking a trauma-informed approach, which, as I said, IJM does some great training on. And making sure we adopt gender and culturally sensitive working practices, among other things. So to give an example of how this do no harm approach can sometimes create tension with other objectives like law enforcement objectives. If we think about a situation where a victim of trafficking may have recently been rescued from a situation of exploitation following a police raid, in Thailand, standard operating procedure is for the police to conduct an interview, an identification interview with a multidisciplinary team with the victim within 24 hours and in any event within 7 days to try and conduct a screening interview to identify whether someone is a victim or not. Now, that obviously serves a purpose. In order to protect someone as a victim of trafficking, you have to identify them. In order to prosecute perpetrators, you have to identify victims. On the other hand, someone who's just
คุณจะต้องทำแต่ว่าคนที่เพิ่งได้รับการช่วยเหลือจาก สถานการณ์ที่ถูกทำร้ายมาเนี่ยนะคะอาจจะไม่พร้อมที่จะทำอะไรอาจจะไม่ปลอดภัยถ้าทำการสัมภาษณ์ในลักษณะนั้นคนนั้นอาจจะยังทนทุกข์ทรมานอยู่แล้วมันมีโอกาสที่จะทำให้เขาทนทุกข์ทรมานเพิ่มเติมขึ้นเพราะไม่พร้อมนะคะที่จะมีประสบการณ์หรือพร้อมที่จะเล่าในการสัมภาษณ์ในลักษณะเช่นนี้เนี่ยมันจะน่ากลัวมากเลยนะครับสำหรับคนที่เป็นโดยเฉพาะที่เขาต้องเล่าซ้ำแล้วซ้ำอีกนะครับกับเจ้าหน้าที่หลายคนดังนั้นแนวคิดของการทำ do no harm เนี่ยก็คือว่าในสถานการณ์เช่นนี้เนี่ยเราไม่ควรจะสัมภาษณ์คนคนนี้เลยนะครับถ้าเขาเพิ่งถูกช่วยเหลือมาเพราะว่า
further violating that person's rights and causing more harm than good when we interview victims. And so there are ways in which those interviews can be done safely and by minimizing the risks of harm. But it's important that we do so because otherwise we will violate our fundamental principle of do no harm. And there are many other examples I could give about how this do no harm principle can cause tension with other systems that we might actually think are for the victim's own good. Related to the idea of do no harm and the rights-based approach is the idea of non-criminalization. So a victim of trafficking may actually commit a number of crimes as a result of being trafficked. So for example, if a trafficker brings someone into a country illegally without a visa, then that victim will have violated immigration law. Or if an employer makes someone work without a visa, again, the person working may have violated labor laws. But because trafficking is about taking away the free will and consent of the victim, what international law says is that we shouldn't hold victims of trafficking criminally responsible for crimes that occur because they have been trafficked. So if someone has entered a country without a visa or worked without a work permit in a country
ทำงานโดยที่ไม่มีใบอนุญาตทำงานใช้พาสปอร์ตปลอม
were trafficked, then we shouldn't prosecute them for those crimes, we shouldn't detain them, and we shouldn't punish them for those crimes. And that can be really difficult to apply in practice because we may not know that someone who we are prosecuting is a victim of trafficking. So, for example, in Thailand, if the border police arrest a large group of migrants who have crossed the border irregularly, as often happens, if those people are simply prosecuted and deported without ever having been screened to try and determine first if they may be victims of trafficking, then we've not done right by them in terms of upholding their rights and in terms of applying this principle of non-criminalization. So that's why having good victim screening and victim identification processes and understanding the definition of trafficking and what it looks like and when to know that someone may be a victim is really important for anyone who's working with vulnerable persons or vulnerable migrants, because there is a risk that we may fail to identify someone and therefore fail to give effect to their rights. Non-criminalization actually also applies to migrant smuggling. So the concept of non-criminalization also applies to smuggled migrants under the Migrant Smuggling Protocol. However, under Thai law, which we'll cover in next week's session, non-criminalization only applies to victims of trafficking and forced labor. So that's the distinction between Thai law and international law on this point. The last point I want to cover is one that is not specific to human trafficking, but actually applies to any work involving children. And this is what we call the principle of the best interests of the child. So this comes from the UN Convention on the Rights of the Child. And what it says is essentially in any action that involves a child. So whatever we do that directly affects a child or involves a child or concerns a child, the best interests of that child have to be our primary consideration. So it has to be the most important thing we take into account in whatever we do that concerns a child. So that may include, for example, things like shelter, protection, support, placement in care, but also, for example, it may concern things like, well, should we require this child to be a witness in a criminal prosecution? So let's take the case of Ploy. If we want to prosecute the trafficker, should we put Ploy, the victim, the child, on the stand and make her testify? Is that in her best interests? And that should be the most important thing in deciding what we do in that situation. Yes, it's important that people face justice. Yes, it's important that the perpetrator is prosecuted. But we have to decide, is doing that in the best interests of that child concerned? So that's what we mean by the best interests of the child. And again, actually, this applies to any decision involving children in any context, not just victims of trafficking. And this is actually covered under Thai law in the Child Protection Act, which again we'll cover in next week's session, and we'll look a little bit more closely how children are treated and protected under Thailand's legal system. So I have managed to finish on time. Just to quickly wrap up, today we've looked at the idea of the spectrum of exploitation as a way of understanding the different crimes of human trafficking, forced labor, and migrant smuggling, and how they relate to each other. We've also covered the key definitions under international law of human trafficking, migrant smuggling, forced labor, and slavery, and looked at how to identify and distinguish these concepts. We've also provided an overview of some of the key international law instruments to be aware of in this space. And we've touched very briefly on some of the key principles to bear in mind when working in a trafficking context. So having said all that, I've been talking for a very long time. Does anyone have any questions that they would like to raise now? Feel free to put up your hand or to put a question in the chat box. So yes, I'll open the floor to any questions that anyone may have in the last 10 or 15 minutes of this session.
Okay.
Hi,
Just quickly, I know that maybe we'll be talking about Thailand case next time, but I'm just wondering, because like looking at some of our case studies that we look at today, I can see that there's a few crimes, like, I mean, there could be several crimes happen in the same case, right? So is there an international guideline on what's the, how do you call it? Like, how do you decide to prosecute them? Like, for example, like I know in Thailand case, sometimes they might hesitate to, how do you call it? Put it as a human trafficking because they wanted to investigate it as part of the money laundering, like, you know, those, or international crime or some other bigger crime according to maybe like their investigation. So I was wondering if that's, for example, if one case as human trafficking, there's forced labor, how do, what would be the legal proceeding in terms of like which court they're going to, which crime they're going to be processed on first?
Yeah, great question. So the short answer is we will cover this in the third session, but there are a whole range of things that should go into making a decision about what crime to charge. So thinking about the quality of the evidence you have available, thinking about whether you can prove the different elements of the crime. So as we've seen, for example, forced labor is actually arguably easier to prove than human trafficking, because in human trafficking, you have the added element of intention. And sometimes it can be really hard to prove what someone's intention is because it's open to interpretation. So all of these things will go into deciding what's the most appropriate crime to charge. And to your first point, we will actually be looking at the same case studies next week through the lens of Thai law, so that we can think about how the same situation might be interpreted differently under Thai law compared to international law, and some of the different types of crimes that exist under Thai law that we could use in this situation. But there's certainly no clear answer. I hate it when a lawyer answers a question with "it depends," but in this case, it really does depend. I also have, so I hope that answers your question. I also have two questions here. First, about whether human trafficking, so the first question here is forced labor human trafficking? And again, this is really difficult. It's not a binary. So a situation can be, as we've seen from the case studies, can be interpreted as being forced labor or human trafficking. The same set of facts, when we apply the law, we could actually interpret it as being either of those situations. Generally speaking, it's up to us to decide what is the most appropriate way to frame a situation, looking at the legal definition, but it's not necessarily an either or, right? There's no clear distinction between, okay, this is trafficking, this is forced labor, this is not trafficking, this is forced labor. As I've said, it exists on a spectrum, and it's up to us applying our judgment and the legal standards to the facts to decide what best fits the situation. And as to the second question I have here, in relation to what's the difference between prostitution and sex work and human trafficking, is it that the sex work is voluntary? Again, remember that yes, it's really important to remember that sex work is a legitimate profession and a legitimate trade that many people participate in voluntarily and without exploitation. So just because someone is a sex worker does not mean that they are a victim of trafficking. It does not mean that they are being exploited. The question is, as you framed in your question, the thing we have to look at is the person voluntarily working as a sex worker? And is the person freely working as a sex worker? And that's what distinguishes sex work from human trafficking or forced labor. We have to really look at, is there genuinely free and voluntary commitment to doing the work? And then I also have a question here about how do you define a child under international law? Under international law, in the UN Convention on the Rights of the Child and in the Palermo Protocol, a child is someone who is less than 18 years old. Actually in Thailand as well, for the purposes of trafficking in Thai law, we also use 18 as the distinction. So someone is less than 18, they are a child. If they're 18 years and over, they are an adult. Okay, if there are no more questions, just before you leave, I would love it if you could complete a feedback survey. So Ryan will share in the chat a feedback survey. I will also share in the chat with everyone the slides and the exercises in Thai and English, just in case anyone missed them. But Ryan, if you could share the link to the feedback questionnaire, that would be much appreciated. We'd love your feedback. We'd love to know how we did. We'd love to know if you have any comments or suggestions. I will just now briefly as well put the slides in the chat in Thai and English for you, along with the exercises so that everyone has access to them. Okay, so having done all that, thank you very much, everyone, for joining. Thank you very much, everyone, for joining. I hope you really appreciated this session. I've certainly enjoyed presenting it with you. If you could please fill in the feedback survey, and I hope to see you all again next week.
Thank you so much, Navin.